And Todd, you heard the 2 guilty verdicts of the 6 charges. The second-degree murder charge, the prosecution going for first-degree murder. Katie talked about the premeditation being that sticking point. What does it say to you with the second-degree murder?
You know, this is a solid jury verdict. I mean, this is all murders are presumed to be second degree unless there's premeditation to take it up to first degree or there's some sort of mitigation to take it down to a manslaughter. This is a solid jury verdict. I mean, you know, there's plenty of evidence of malice with the emails that he sent, with punching through the door, going in there, you know, and you know, there's plenty of evidence of malice which is required for second degree. Now he's looking at up to 40 years on second degree, up to 20 years on a grand larceny, and the jury will next hear in the sentencing phase about any prior convictions, which I understand he's got a couple misdemeanors involving alcohol and some sort of a resisting arrest.
Yeah, a little bit of violence there. Tell me, so is the prosecution feeling pretty good here, or does the defense say, well, they couldn't get us on premeditation? How do you interpret that?
I think the defense would have considered it a victory if they got a manslaughter. I think people kind of expected a second degree in the legal community. You know, nobody wants to try to predict what a jury's going to do. But a prosecutor's got to be happy with that. I mean, come on, we're talking about 60 years total that they have to work with here. And realistically, you know, breaking and entering with intent to commit the larceny, I don't think that there was evidence that at the time he broke in, he intended to steal the laptop, you know? So this is a solid jury verdict. It's based on the evidence, and I think maybe that delay of 3 days might have been a good thing for them because it really got to kind of settle in with them.
And as far as the sentencing phase going on now, you heard Katie mention they've been deliberating about 9 hours today. Is that a factor? Might the judge just say, hey, do you want a clean sweep of it tomorrow morning? Or if you're the prosecutor, are you eager to go through as well? How does that all
I mean,
play out?
I sure would expect them to go to tomorrow. I mean, this is getting to be late now, and if they're putting on a couple hours of evidence and they're going to have arguments, I mean, I certainly expect this to go to tomorrow. It's just a very taxing, long day, and I don't think the judge wants to put them through this. And keep in mind, there was 2 alternates before they came in today, and so that kind of buffers the risk of a mistrial. Now those alternates are gone, so when you go to that next day, there's sort of that increased chance of a mistrial. But as long as everybody behaves themselves and doesn't, you know, read the paper, and they come back and do what they're supposed to do, and it looks like a very attentive jury, then I would expect them to do just as well tomorrow.
And we had heard that one of those 2 jurors, the alternates that were dismissed today, as happens in this case, that's a normal procedure, one of the 2 had been emotional during some of the testimony. Obviously, the others reached the verdict they did. When you said a chance of a mistrial, that means not just somebody not showing up. That means somebody, like you said, watching TV, reading a newspaper, getting some other input than what the judge is going to, or the prosecutor in that case.
That's right. They're supposed to base their decision solely on what happens in the courtroom, not on what happens on the television or what they read in the newspaper. And so, as long as they don't, you know, go beyond those boundaries set by the court, then, you know, I would expect them to come back. This is a very well-reasoned decision. It really is. I mean, a second degree and grand larceny, I mean, there's plenty of evidence to support both of those, and I can understand why they might not convict him of some of the other things that they didn't convict him of. So
that's right. Some of those others were the burglary, statutory burglary, robbery. And as you said, those things, some of those require intent beforehand, in which case
right.
He'd have to have said, I need that laptop, I'm going to break in there and steal the laptop.
That's exactly right. And it didn't look like that was the reason he broke in there. And a robbery specifically is a taking of property through the use of force, threats, or intimidation. So did he go in there to get that laptop and then use force to get that laptop? No, realistically, probably not. And that's a prosecutor charging everything we can possibly charge. But the jury did a good job of sifting through it, looking at the law, looking at the evidence, and really applying the facts to the case. And as I said, I think it's a very well-reasoned decision.
And when you say step back and say, well, they deliberated about 9 hours, is that normal for a 2-week trial going into its 3rd week today? I
mean, that's a long time to deliberate, but again, we're talking about 2 weeks, and we're talking about a lot of evidence that was put out there. So it's really not that long in retrospect. I mean, when you compare it to how much evidence was put on, yeah, it's not that long.
All right, I'm going to put you on hold for one quick